EDUCAS WJEC specification asks us to consider how Aquinas natural law would be applied to the ethical situation of voluntary euthanasia. Firstly, it is important to clarify some terminology. Voluntary euthanasia involves the deliberate killing of a terminally ill person who has chosen and clearly asked to be killed. It requires direct action to kill by another person, for example, a doctor, because the patient cannot do it themselves. This is illegal in the UK. Some people have been known to travel abroad to places like Dignitas in Switzerland, but what they receive is assisted dying. This is where a terminally ill person can perform the act themselves, but needs little help to do so. The terminally ill person must be able to voluntarily administer drugs that they are provided with for themselves. As in the case of abortion, it is important that when writing an essay, students do not get caught up in the descriptions of euthanasia or the unpacking of the actual moral dilemma at the expense of the question, which will ask for an application of the theory of natural law. Therefore, this film will demonstrate the application as you would be asked for in an essay question. Remember, this is demonstrating AO1 skills of knowledge and understanding. It is not asking you to consider whether the moral judgments are reasonable or correct in your view. Divine law suggests that voluntary euthanasia is morally evil. Exodus shows the 10 Commandments forbid killing, and in 2 Samuel 1:1-16 there is an account of a soldier who is punished by David for hastening the death of King Saul when he's mortally injured on the battlefield. Natural law also forbids killing. The primary precept to preserve life means that one can easily see secondary precepts would forbid euthanasia, even when it is voluntary. It would also forbid assisted dying, as the precept clearly states that life should be preserved. This is simple, but of course many would object to the ruling on the basis that it seems to show little compassion for the person who is terminally ill, whose death is certain, and who may be suffering physically or mentally from their situation. A long drawn-out death, or one in which one's dignity is lost, seems to be a good case for making an exception to the rule, or even ensuring that the rule allows people to choose the time and manner of death for themselves. However, such reasoning is not rector ratio, because it is based on things other than the act itself, such as consequences or situations. This leads us to an apparent good. It seems like it would be good to allow voluntary euthanasia because the consequences of not allowing it seem too terrible. A lesser evil seems to be the better option, but natural law says it is not. In natural law, the assessment of the morality of an action does not involve the assessment of possible consequences, as the only or most important part of an ethical action. Of course, consequences matter, but they are often unpredictable or uncontrollable. Instead, the duty is to use right reason to discover the real good and then do this for the sake of the beatific vision, fellowship with God. Real good involves preserving life, even if that means that the person experiences suffering. The virtues of faith and hope allow a person who makes this decision or who lives with the consequences to trust God that his will is done and that he will provide the relief that the Gospels promise in the afterlife. Of course, there are some times when precepts conflict. If a person is suffering and their dignity of life is not being protected by keeping them alive, and their pain is not under control, it is possible that a doctor can cause the death of a patient and still be blameless. It is vital to remember that a person may never intend to kill. Just as in Aquinas' example of killing in self-defense, killing may be accidental or a side effect of the action that intends to uphold a precept. This is the law of double effect. No doctor may ever set out to euthanize their patient, and double effect cannot be used as a loophole to allow people to intentionally kill another person. However, double effect means they may administer pain relief or sedation with the intention of easing suffering, even if they are aware that this act will result in death. The death is not their intention, but their actions brought it about. In this case, they would be morally blameless according to natural law, because they intended to uphold the precept of defending life, but were unable to do so because of the conflict brought about by the only action that was possible to relieve the suffering. There was no direct action to kill, but it was a side effect of upholding the precept. Such an action must be proportionate to the situation. It would not be acceptable for this doctor to administer a lethal dose of pain relief to someone who could survive. For moral agents to make morally good decisions requires them to be virtuous people. The doctors and the patient will benefit from developing the virtues because it will enable them to have the fortitude to make difficult decisions under stressful or painful circumstances. Temperance will allow a doctor to moderate their behaviour so that it is rational and will allow relatives to avoid making an emotional rather than reasoned decision. It could be easier in such circumstances to ask for release from life when suffering becomes too difficult. However, natural law would argue that those who are prudent will consider the good act rather than the act that they desire, and will have faith that God will have mercy on them and reward them for their virtue and their desire to uphold natural law. The virtues of love and justice will ensure that the patient is treated with dignity and not simply left to suffer or disposed of through killing as though their lives were not valuable or sacred. There can never be a circumstance in which the intentional killing of a patient would be acceptable, and therefore as a deontological theory, natural law says that it is our duty never to allow voluntary euthanasia to take place. Instead, the Catholic Church promotes the use of hospices and palliative care rather than simply allowing people to suffer. It declares voluntary euthanasia and assisted dying as intrinsically evil and a grave sin, and has instructed priests to attempt to change the mind of those who intend such deaths and refuse to be present if they do not. Charity or love is the virtue that ensures such a patient in this state is not neglected, and they are shown compassion and care through hospices and high-quality palliative care. Pope Francis has stated that the elderly, sick and disabled should not be undervalued or thrown away. The Catholic Church is also cautious in its approach to protocols that allow patients to refuse treatment so that they may be allowed to die or their death hastened. As recently as September 2020, the Church made a statement that declared that whilst DNR orders and variations have been in place to avoid aggressively prolonging life when people have no hope of survival or recovery, they could prevent medical staff from safeguarding life when they could reasonably do so. Such protocols should never be used to hasten death or deliberately cause it. This would be a sin against human life. Whilst patients should be able to decline aggressive medical treatment and die with dignity and be allowed deep sedation if necessary, medical staff are obliged to provide basic care such as food and hydration, even if they are in a coma.